In breaking news, the Department of Justice and its third highest ranking official, Stan Woodward, have filed a piece of paper with Judge Brinkema in the Eastern District of Virginia and told her to go pound sand. They are not going to file affidavits, sworn statements, sworn testimony under oath by Todd Blanche or Scott Besson or Stan Woodward himself to declare for her, to her satisfaction as the fact finder, that the Anti-Weaponization Fund has truly been put out of its misery, that it's truly been killed by the Department of Justice. Judge Brinkema last week ruled in a case brought by Democracy Forward, our friends, that if the federal government wants to get out from under this jurisdiction of the court and prove to her that it is moot, they need to file affidavits by Friday. And instead of filing an affidavit, it's attesting under oath to have Todd Blanche swear under oath that he really is walking away from the Anti-Weaponization Fund, while Judge Williams in Miami considers later this same day the reply brief of 35 sitting federal judges about whether she should find fraud in the court, fraud on the court, and deception, and strike the settlement agreement down and the resulting weaponization fund for a whole different set of reasons. As I predicted, and as I discussed with Sky Perryman, who's on Democracy Forward, the leader of Democracy Forward, and led the charge in this case, there was no way that Todd Blanche was going to file under penalty of perjury any statement because a federal judge told him to. You're on the MeidasTouch Network and Legal AF. I'm Michael Popok with the breaking news. Let's go over and let me read to you for a moment in the filing that we just obtained, and I'll post to Legal AF Substack. Here's what Stan Woodward has filed on behalf of himself and presumably the others in the case. Page 2, the court stated that it will dismiss this case as moot only if the Acting Attorney General Todd Blanche, Associate Attorney General Stan Woodward, and Secretary of the Treasury Scott Besson file, all caps, a declaration under penalty of perjury that they will not seek to take any action to create or operate the fund, and that the fund will not proceed in any manner. And if it's not filed by Juneteenth, the court will issue a scheduling order requiring a responsive pleading by July 17th. They say such declarations are unnecessary, and the compelled testimony of senior officials implicates serious separation of powers, so go pound sand, Judge. Those are my words. They say that Todd Blanche already testified before Congress that the fund is not going anywhere, period. And so that should be enough for the judge. Look, the judge made clear in that courtroom that this is a courtroom of law, and facts and evidence have to be adduced within its four walls, not some random statement made by Todd Blanche. In fact, here's Sky Perryman, who was in the room during the hearing, and how she evaluated Judge Brinkema's position. Play the clip. There's a comment about Blanche and Todd Blanche. So why won't he just provide a document of rescission or novation or whatever it's going to be to just put this out of its misery? Well, I haven't spoken to Todd Blanche lately. Yeah, you said that to Judge Leon, but it's been a couple of days now. Very important case. The eyes of the nation are on you. Are you telling me you haven't spoken to Todd Blanche? Talk about that, because here we have yet another example. And this is my own speculation. Todd Blanche is not filing an affidavit. This is yet another example of Todd Blanche not willing to give sworn testimony in a courtroom, even if it means the Department of Justice loses.
Well, it's quite remarkable, actually, that you have a Department of Justice that is willing to make statements to a court in their briefing that they're not willing to, at this point, to swear to. I mean, maybe they will come back and surprise us, but I'm with you. I don't know that they're going to be filing an affidavit. And the government's attorney, Block, at the hearing went into an entire soliloquy about how he's made these representations as an officer of the court. Well, that's kind of the point. If you're making these representations as an officer of the court, then why is it too much to ask that you make them under penalty of perjury. And this is something the Department of Justice has not been willing to do. And so I think it really highlights a theme you and I have been talking about for these last 18 months, which is actually the overall way that the Department of Justice is operating before the federal courts. It's unlike anything any of us as lawyers have ever really seen. I mean, this is quite remarkable behavior, and it should not, of course, be normalized, which is something that we're trying to emphasize to people. It just seems like every day there's a new way in which this Department of Justice is trying to pull one over on the federal courts, and Judge Brinkema wasn't having it.
So they go on to say that a federal court does not have jurisdiction because they're citing to a case by Judge Leon in the District of Columbia. Eastern District of Virginia is not the District of Columbia, in which he agreed that the case was moot. Although he did warn the Department of Justice, Judge Leon did, the ballroom judge, that if he sees the fund come back, there will be serious penalties to be paid. They go on page 3 to say, nor is there any basis for the court to compel testimony from the Associate Attorney General and 2 cabinet members, saying that there's an Article 3 limitation on such judicial review. Accordingly, the court's demands are unnecessary. The transcript of the testimony is attached, and that should be enough for the court. Let me play the clip that they're referring to of Todd Blanche. Play the clip.
Mr. Attorney General, I wanted to ask a few questions about the Anti-Weaponization Fund. We know that the department has agreed to pause this effort until at least June 12th. I wanted to ask what your plans were for the fund after June 12th.
So thank you. So look, we're not moving forward with the fund. You're right that there's a date that in the case in the Eastern District of Virginia in June, but we are not moving forward with the fund, period. The reasons for the fund is something that President Trump talked about for a long time, which is the fact that there were a lot of people in this country who had their government weaponized against them. The reasons for the fund, I think, it remain as important as they were before, but we are not moving forward with the fund.
Not moving forward ever?
Correct.
Oh, there's no more fund then?
Well, to the extent there was a fund, and remember the fund wasn't set up yet. There were no commissioners named. There was no claimants brought anything in front of. There was no claims made yet. So yes, we're not moving forward with the fund.
All right, let's be real. Who likes wearing a bra? Nobody, especially when you're working out, right? Sports bras are terrible to wear most of the time. And whether it's that they dig into your shoulders on the straps, or the band rolls up and feels too tight around your rib cage, or whatever it is, they're a pain to put on, they're a pain to take off, and they're so uncomfortable. But Honeylove has this sports bra that is different, and they have this wonderful new product called the Honeylove Cross Flex Activity Bra, and it immediately felt different from every other sports bra that I have worn. It feels like a sports bra with a support, but it's also designed for all-day wear, and it's supportive without feeling too tight, too stiff, or suffocating. It has an easy to take on and take off, and it's wireless using their technology called Cloud Fuse. So there's no poking or digging or pressure points, which is actually what I love the most about it. And it gives you, of course, great shape and separation instead of that uniboob look that sports bras can often give you. So if you find yourself reaching for a sports bra on a daily basis, and because you need the coverage and you need the support, but you're looking for something comfortable that you could also wear all day, I highly recommend the Honeylove Cross Flex Activity Bra as the solution you've been searching for. So it's really fantastic. They are now offering a crossover triple bra bundle. So if you want a full refresh on your top drawer, you can get a huge savings by buying 3 at once. They are an independent female-founded brand with products designed by women who actually wear them, including the founder, Betsy. Honeylove doesn't just make bras and shapewear. They've built a full line of tanks, bodysuits, and underwear with supportive structure, smoothing fabrics, and premium finishes. And they recently launched their new crossover contour bra, which features their best-selling wireless crossover bra design, plus built-in molded light foam pads for extra support and beautifully contoured shape. Treat yourself to the most advanced bras and shapewear on the market. Use our exclusive link to save 20% off Honeylove at honeylove.com/legalaf. That's honeylove.com/legalaf. And after you check out, they'll ask where you heard about them. Please support our show and tell them Legal AF sent you. Experience the new standard in comfort and support with Honeylove.
Now, I think it's ironic that the person who signed this, let's go to page 4 here, put it up on the screen, Andrew Block is the same Andrew Block who opened up the hearing last week and had Judge Brinkema say out loud, "You are a very brave man, Mr. Block," and it went downhill from there. As she said to him, effectively, "I don't believe you. Have you spoken to the Attorney General?" In this case, Todd Blanche, about his view. He said he had not. The judge responded by saying, "I find it inconceivable that given so much attention to this case that you have not spoken to Todd Blanche." And now they're telling the court, screw it, where you're never going to hear from Todd Blanche ever in this case under penalty of perjury. And you should just live with whatever he says out in the real world as opposed to in your courtroom. That's not going to be good enough. If I know Judge Brinkema, she's going to be pissed off by this filing. She's going to enter the scheduling order requiring a responsive pleading by the 17th of July, which they've effectively baited her to do. And at the same time, you've got what's going on in Miami, which I'm waiting to report on as well. Judge Williams gave the 35 former federal judges until Friday as well to tell her why she should find fraud on the court against Donald Trump, his lawyers, and presumably the Department of Justice. The Department of Justice didn't file an affidavit under penalty of perjury in that case either. They didn't file testimony of Todd Blanche. We will never hear testimony of Todd Blanche except when he's in the confirmation hearing, because he'll never testify in a court of law. They are willing, as a Department of Justice, to lose cases rather than put Todd Blanche under oath. What does that tell you? It tells you everything you need to know about the Department of Justice and the feckless spirit of Todd Blanche. They lost a case in the Middle District of Tennessee involving Kilmer Abrego Garcia. They were willing to have a court find that the Department of Justice had vindictively prosecuted somebody rather than have Todd Blanche testify in order to satisfy the judge and their burden. Period. So does this shock me or surprise me that we're watching the Department of Justice once again refuse to bring Todd Blanche before a court? He's a coward. He'll do anything to get this job as the Attorney General, and everything that he's doing is a disqualifying event. Look, in the last 48 hours, I've reported on alone 2 federal judges in Chicago, Judge Coleman, Judge Perry, both looking at whether they should appoint special prosecutors to look at whether there's been an obstruction of justice and a violation of court orders for contempt in 2 different cases, criminal cases in Chicago, and whether it goes up to the highest levels, including Todd Blanche and maybe the White House. That's just going on now. Same thing's going to happen. I'm sure that Judge Williams is either going to rule on the papers in Miami against the Department of Justice, against Donald Trump, find there was fraud and deceit on the court, or she's going to appoint another special counsel. So if you thought the days under the current administration of talking about a special counsel are over because they need to get out of the DOJ for that to happen, forget it. Judges have the ability under Federal Rule of Criminal Procedure 42 to appoint special counsels under these unique circumstances, period. It's just remarkable to me that they are playing with dynamite. They have the Department of Justice, Todd Blanche, has no respect for the federal courts, no respect for federal judges, no respect for federal juries, no respect for federal grand juries, no respect for the American people. And that any one of those things, and there are a dozen of them, are going to be used against Todd Blanche in his confirmation hearing sometime around the 15th of July. In fact, it sounds like they're going to have to file a piece of paper to Judge Brinkema in this case I'm describing right around the same time. He's going to have a lot of explaining to do, if you know what I mean. And he's going to have a lot of answering he's going to have to do to people like Sheldon Whitehouse who I recently interviewed about how they're going to take on Todd Blanche about things like not testifying and not supporting their cases or admitting to bad faith practice. Here's a clip of Senator Whitehouse and me in the last couple of days on this issue. Andrew Boutros has his office dismissed with prejudice an $800 million COVID testing fraud scheme rather than turn over the emails and everything else about the misconduct in the grand jury, although Judge Coleman is holding a hearing today about that. They'd rather let two people go and give them a get-out-of-jail-free card than to have somebody from the Department of Justice testify or turn over their documents.
And what they forget is that grand jury misconduct, if it was performed, is complete when the grand jury misconduct is. And it's an offense against the court that supervises the grand jury. Fraud upon the court is complete when the fraud upon the court is performed. It's not like you get to get rid of the case and have those questions go away. And I think the record of the department is such that judges are simply not giving them the benefit of the doubt about misconduct. They're going to want real answers about complete contempt, completed misconduct, completed fraud upon the court, and dumping cases. Just it doesn't really help. What it does is it shuts up a plaintiff who could have done a lot of digging. I'm sorry, a defendant who could have done a lot of digging into the misconduct as part of their defense. But if the court's willing to step in, it's still going to be the subject of inquiry, and deservedly.
So I'm glad you're here. You can find the filing that I just read from on Legal AF Substack for paid members. Until my next report, a traveling Michael Popok for the MeidasTouch Network and Legal AF. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.